It's incontrovertible that seatbelts save lives and minimize injuries in car crashes. It's equally indisputable that car crashes provoke lawsuits. Can the defendant in a collision case introduce evidence that the plaintiff wasn't wearing a seatbelt when the accident happened? The Texas Supreme Court buckled up to answer this question in Nabors Well Services versus Romero. Martin Soto was driving a Chevrolet Suburban carrying 8 members of the Soto and Romero families. The Suburban was involved in an accident with a Nabors Well Services truck. Aydee Romero, a passenger in the Suburban, was killed, and the other 7 occupants were injured. The Romero and Soto families, whom we'll call collectively Romero, sued Nabors and the truck driver. At trial, Nabors sought to introduce expert testimony that 7 of the 8 Suburban occupants weren't wearing seatbelts and that their failure to do so caused their injuries and Aydee Romero's death. The trial court excluded all evidence of seatbelt non-use. The jury found Nabors 51% and Soto 49% responsible for the accident and awarded Romero just over $2.3 million. The Texas Court of Appeals affirmed. The Texas Supreme Court granted review.